Karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia ngā kinakina ki uta, kia ngā tangata ki tai, kia he api ana te atapura, he tio, he puka, he pouhu, ti hei mauriora.
Tēnā koutou katoa, welcome to day 2 of Hearing 16. We have Mr. Peter Hall with us, Benson Farm Limited, Sita 36 Limited, and Aldi Trustee Limited. Good morning, Mr. Hall.
Good morning.
Peter, over to you.
Thank you very much. This was just apology, it is the second to last hearing of the attending. I've got one small appearance at the hearing 17, so
Wouldn't be here without you.
thank you very much. Today, obviously, subdivision and specifically certain aspects of subdivision provisions. And just, I suppose, to restate from my evidence, my background in that goes back to the subdivision provisions as they were mediated through the Operative District Plan back in 2005-ish, and it's good to catch up here with Mr. Riddell, as we were both involved in the mediation at the time. I know that Andrew will provide some further context as to those which include management plan provisions. I was actually in that capacity there then on behalf of Benson Farms also, so again here on behalf of Benson Farms and other parties as well.
Are you able to give us an update as to how it's progressed since?
Well, the management, certainly I can, at least in relation to Benson Farms on Marino, which I think I touched on in earlier hearings, which is the coastal subdivision management plan, and probably I think the first management plan presented at the time, and that has involved over 1 million native plants planted across 140 hectares, 17 lots, and having returned through that property in the course of preparation for these hearings, I was very heartened to see the progress of that with that wholesale replanting and the application of the design controls to the buildings which have been built. The sites, at least on Marina, are not fully occupied. I think I've talked about that in previous hearings in relation to the overlays. So management plan subdivision is one topic I talked about in my evidence. I wanted to specifically dive into the subdivision policies relating to management plan subdivisions and rural lifestyles subdivision. I wanted to also discuss the environment benefit subdivision rule assets, where in particular the requirement that the minimum balanced lot size be 40 hectares and suggested to not apply. In my evidence, I also just recapped on the evidence I presented here in relation to minimum lot size of 20 hectares rather than 40 hectares in the rural production zone. But I don't propose to represent that evidence. It is, as I say, just for reference, included in my evidence. So, two key topics: firstly, management plans, and secondly, environment benefit subdivision plans. So, to confirm, I support the inclusion of management plans in the proposed district plan. I see that as a vital and necessary tool to provide for a transition of land use and environmental outcomes which otherwise wouldn't occur with the land not to have that injection of capital, and something I've previously described as a community of care, which in essence is a collective of owners that are funded to care for land and also deliver the outcomes of management plan through residents, association levies and the like. And that's the sort of model which certainly continues to operate at Marino. Mataka Station, which we've discussed in previous hearings, wasn't a management plan subdivision, but it presents that same sort of model as that. It was significantly with significant benefits and outcomes. The policy I wanted to focus on is subdivision policy P8, which sets up avoid rural lifestyle subdivision in the rural production zone, unless the subdivision goes on to set out certain exceptions to the avoidance. I'll go through the specific changes I'm proposing to that, but there's two key issues with that, as I've explained in my evidence. Firstly, what is lacking in that policy is a clear and certain expression of the outcome sought by management plans and environmental benefit subdivisions, and the policy course of action to achieve that outcome. So, in the absence of that, there is uncertainty for future applicants, community and decision makers exactly what our management plan is to be tested against. And bear in mind, of course, a management plan subdivision is a discretionary activity consent. It provides for certain outcomes, as are stated at the moment, only in the appendixes information requirements. And so therefore that's a clear policy basis to set out what the outcomes are. And that's really the focus of my evidence in that respect. So secondly, it's really the structure of that policy as it's presented subject to sub B8, which adopts what I've described as an undesirable drafting approach of referencing requirements to rules. And so this mixes policy with methods, and I think should be avoided as a drafting approach. It, for example, directs that rural lifestyle subdivision be avoided, as we know that avoid means avoid, unless it will protect areas of significant vegetation in perpetuity as required by subdivision rule R6. It should be avoided unless it achieves the environmental outcomes required in subdivision rule R7, and or unless it's around an existing residential unit as provided for in subdivision rule R3. And the effect of those references in policy is to effectively require compliance with rules in order to achieve the policy rather than to set up the broad directive. And by its nature, discretionary activities assessed against the policies, and so therefore the policies need to set out what is actually being achieved. And what it sets up what I describe as a policy loop, because as soon as one proposal application doesn't comply with a particular rule, it doesn't meet the shall comply with the rule test, therefore it should be avoided. And so that's why that in my evidence I've set out a different approach to those policies. So paragraph 7.16, my evidence sets out what I'm suggesting is a better alternative.
Perhaps you can just take us through that. We had some discussion about this policy yesterday, so it's definitely a frame of attention.
Yes, so, I suppose the first point of my changes from 7.16 is to change avoid to provide. And as I said in my evidence, there's another policy which sets out the avoidance obligations in respect of the rural production zone. And so, in essence, I'm saying that the policy should actually set out a positive provide for rural lifestyle subdivision in specific and limited circumstances as set out in the policy. And those are where subdivision. And then in my policy, I sort of separate out the different circumstances where that applies. So firstly, we will protect areas of significant indigenous vegetation. And that in effect is environmental benefit rule R6. But what it doesn't do, it doesn't say as required by subdivision rule R6. As I said earlier, if there was one step outside of the specifics of that rule, it wouldn't be a policy that could be avoided. It's not good policy drafting. The second part of my recommended change is the one that provides for the management plan, which Benson Farms and others were a submitter in part support of Mr. Avell's submission in this respect, plus they've had their own submission point in respect of this policy. And so the changes I am recommending here in effect take the council officer's recommended policies and work into that framework submission and further submission points sought by the submitters. And so in relation to management plan, again, the positive provides a management plan which enables a more intensive and innovative form of subdivision use and development, which results in superior environmental outcomes. This is the first part. And so those words are a carryover from the operating plan in effect. And as is the management plan subdivision, something I probably should mention at the beginning, it's not a new provision in the plan. And again, so it sets up what is the essence of the management plan within the policy itself. And I think importantly are all superior environmental outcomes. And so that automatically points the planning user to something which is better than just straight subdivision. But I think the other aspect of these policies is the continuum of policy and rural framework here. With the management plan, at one end being the discretionary consent, the environmental benefit subdivision rules are the more sort of mathematical approach. You protect this much, you get this much as a restricted discretionary consent. So, bear in mind we are in a full discretionary world in management plans. So, I had proposed to then add some more colour to that as to what sort of things should be achieved or encouraged, and that's including where relevant protection of natural character, landscape, community heritage, cultural values, and where relevant is important because not all sites have those values, and so we can't set up a policy that requires all of those things to be done. And or the restoration, enhancement, legal protection of indigenous biodiversity. That picks up on the recommendation from hearing 4 in relation to indigenous biodiversity, where officers recommended that subdivision be enabled where it achieves the restoration and enhancement of legal protection of indigenous biodiversity. So really that points to 2 key things. One is around protection of certain features, and the other one, I've probably talked about this in most other hearings, is around the restoration of indigenous biodiversity, both as outcomes, which I believe should be encouraged in management plan subdivision. The rest of the policy then just C then refers to the change recommended or incorporates the change recommended for in the section 42A report for the subdivisions around the existing residential unit where one rural lifestyle allotment is created and the balance allotment of sufficient size to satisfy policy rural production P6. And again, that picks up on the essence of as provided for in the rule, but really tries to set up what is the policy outcome sought by that rule rather than referencing back to the launch. So that, as I say, is really the essence of what I think is an important conclusion to setting the policy base of management subdivisions.
You haven't had some questions?
Yeah, that's a logical pause. I was going to talk to the.
I think you're on to subdivision lot size next.
Yeah.
Okay. Yeah. Okay. No, I understand. I understand definitely where you're coming from. I understand your loop argument. But that issue could be resolved by just not referencing the law and crafting around that. But what I want to ask you some questions on is this question of avoid versus enable or provide words you use provide. It seems to me that the only ways that you can get a lifestyle subdivision in the rural production zone is via the management plan process or the environmental benefit process. Literally, your policy pretty much states that. So, in that sense, what is wrong with the avoid policy saying avoid all other forms of subdivision unless you are one of these 2 things and you meet those standards? I mean, because there is a rural strategy that we had presented back in the hearing. No, I don't think we were hearing.
Yes.
And there was a strong emphasis backed up by technical, economic, and rural production assessments of Section 32 that talk about really protecting the rural environment production capacity, but also acknowledging that certain things that your clients are able to be provided, but specifically, as opposed to might be. So in that sense, the rural strategy sort of is a bit of an avoid unless. And I'm just wondering what's wrong with that approach, and from a resource management point of view, why don't it have to be? Why should you think it should be provided for as opposed to unless?
Two reasons. One structural and the other a bit more substance. But dealing with the structural one first, the new subdivision policy PX, there's a double avoid, I suppose, that's set up. And so if I can direct you to subdivision PX, which talks about avoid subdivision that results in rural lifestyle subdivision unless provided for in sub P8. So you've already got that avoidance unless provided.
But also, if you take away that issue, and if you take away the issue of it being linked to a rule, what is wrong?
Oh no, that's been linked to another policy, and so that's to the policy.
That's linked to the other
points to policy. So that I agree sets up a avoid rural lifestyle subdivision unless provided for, and so then we're in what is provided for in the previous policy, and that's why. But one of the reasons why then points to subdivision policy P8, the previous one, then needs to set up a provide for. What are the rural lifestyle opportunities actually provided for? That's the sort of structural answer. One of the more substance answer goes back to, for example, Indigenous biodiversity. Here in the office is recommended enabling subdivision where it provides for the protection of Indigenous biodiversity vegetation in accordance with the management plan and the environmental subdivision law. And so again, that sets up an enabling provision, which in my view points to provide for something and specify what it is that is being provided for. So yeah, in summary, against the sort of the framework, because there already is that clear directive in the own policy which talks about that and is provided for. So in the next policy, logically, it should say provided for.
Do you think the order of policies is important so that you sub-PX should come before?
Absolutely, I think it's that, yes, I think logically it would.
Yeah.
Yeah, in the way I'm explaining it, that's exactly right. We would set up that avoid and then go to drop down to what is the provision.
And would logically follow from that PX before provision.
Yeah, that's exactly it.
Yeah, okay. Any questions?
I'm following them so far.
Okay, thank you.
So the second part of my evidence was that I want to talk about is environmental benefit rule. And I support the retention environmental benefit rule, which again is a restricted discretionary. So as a result, it sets up a framework that allows for subdivision where certain amounts of discretion met. As I say, that's quite distinct from management plan subdivision, where there's no guarantee that a consent would be granted. And accordingly, it provides for that in the rural production zone. The part of that rule I don't support is the requirement of rule DIS 6 of rule that the balance lot must be greater than 40 hectares. The principal reason here is the retention of 40 hectare balance lot would nullify the application of the rule as a restricted discretionary activity to the majority of sites in the rural production zone, and I use the majority of sites with reference to work that was done for the council in section 32A reports for rural production which identified the lot sizes and equivalent of that area in my evidence, which granted some farms comprise natural lots, but even that I would say would be to say the majority of sites in the district are in fact less than 20 hectares in the rural production zone. So having that 40 hectare obligation to in effect allow for 1, 2 or 3 or whatever is allowed through the numerical application will lots to be created, but then have to create a balance lot of 40 hectares nullifies the application to the majority of sites. And I do note there that includes coastal sites where there are many coastal sites that are less than the required 40, certainly less than 20. And in those circumstances, I think there is particular need for the protection of Indigenous biodiversity as is sought to be provided by that law. The officer's response to that was what, in essence, as I understand it, is that rubs against the policy framework of design, which is to avoid fragmentation of rural land. And I suppose the simple answer to that is yes, but that is the very essence of providing to the rural lifestyle subdivision. It will fragment lands to a size that is no longer productive and no longer necessarily presents the same sort of density as would otherwise be provided from the zone. By its nature, also the obligation to protect areas of bush or wetlands preserves openness, and so against that framework, I don't see the need for that 20, 40 hectare or that needs a balance requirement in relation to that law.
So you're seeking no?
No balance lot size, that's correct.
I take it the balance lot would include any areas, most of them include the areas of vegetation.
Yeah, logically, yes, that's correct. Logically it would.
So, but what also too is I think one of the presumptions behind 40 hectare is allowing that balance lot to be used productively. And that's not inconsistent with lifestyle subdivision. It's not elsewhere.
Well, it's not inconsistent, but nor is it necessary because on smaller lots, of course, that simply couldn't be achieved. And
But playing devil's advocate, when we went to medical station and tour around there, but they're using quite a lot of their times areas for productive capacity. Like sheep, cattle, and all sorts of other productive things. And it was explained to us, Mr. Williams, that that provides necessary income to fund some of the conservation efforts, certainly some of the maintenance and ongoing pest control and stuff. So you had embraced using those areas. That's something we're obviously having regard to as well.
That's right, and certainly that is the case. And of course, the structure of Matica is there's a particular structure whereby the land is all subdivided into that capacity 20 hectares, and then a farm license, if you like, operates over the site seamlessly as if there weren't internal boundaries, and so that allows that rural production capacity to continue, as you say, quite rightly so. Is important for the farm and conservation of that's multiple station. So that's the particular opportunity that site presents.
Okay, well then we then went next door to the landing, and you're familiar with that site, obviously, and they're using that land productively too, but it's a winery. And they chose not to have cattle. We didn't really fit with their aesthetic, but certainly they're looking to expand their wine production. That's using their numbers quite productively as well, isn't it?
Yeah, that's right. So that's another very large property. So I think what the panel needs to be very wary of is the majority of properties which aren't of that size, which in my opinion warrant a better approach than non-compliant activity in seeking the application of this rule.
Yeah, yes, but you're seeking that there be no balance, not just to change the activity status. What are the activity status? Well, if it became discretionary, so that still have a presumption for compared to a minimum, but could be a discretionary activity. Otherwise, you have to put your case.
Yeah, I think the difficulty then is that you have to put your case against a policy framework which avoids non-productive use of land, and so that is very difficult to achieve on a property which doesn't have its quota of lot size. So that's where I think it's actually better to deal with it overall, except that that there is a variety of lot sizes across the district, and as I say, many under 20 hectares.
In your experience, I mean, how do those balance lots get managed if they're not used for rural production? What would be the normal management response? I mean, obviously, even if you had 20 hectares, you don't just sort of leave it.
No, and it will depend, and I think that's where the environmental benefit subdivision rule comes into play, because that requires management of the feature. And so then what is the feature? And in all likelihood, it would be part of, or perhaps all of that balance area where you have, for example, bush lot.
Yeah. So I think obviously you would have areas which would probably tend to be in gullies and steeper areas, because that tends to be the areas that haven't been farmed, right? Then you'd have the areas that the management plan may require planting, and then possibly associated with gullies and things. But there's always this expectation that there's going to be quite a lot of pasture. And so how does the pasture be managed?
No, I don't think there's an expectation of pasture. So again, I'm pointing to many properties in the Bay of Islands where if there was pasture, it's long since gone, or it's well into reverting, and that in fact is a good outcome. So
that's a natural regeneration,
which can be encouraged through a management plan type of outcome, or through environmental benefit subdivision. So no, I don't think there's necessarily an expectation that it would be farmed. I would, in all likelihood, there might be an arrangement of joint ownership through some sort of residents association to collectively manage the balance area, which at that sort of scale I would suggest is not much more than using sheep to mow the lawn, rather than any sort of real productive outcome for that region.
That's one of the issues.
Yeah, just on that part of the rule that you're looking to delete, could you keep some of it and just delete the 40 hectares as a metric? Could you indicate that there must be a balance lot, but not give a metric to how big that balance lot is?
Yes, you could. Yes, you could. If that's of value, because the indication of a balance lot may, for example, be the protected portion. In saying that, I think there's the flexibility in the law to allow the protective portion to potentially span, say, 2, 3, or whatever of the lots that are created under that, which might be an outcome also, bush or a wetland, or whatever the case may be. So I did think it was simply providing for the outcome, which was the creation of more residential lots without specifying a balance of areas akin to
because otherwise you get into debate about how's that rule suited.
And I think inherently in the rule there is that debate, because the debate is, well, what is the size of the area to be protected, and what is that, how is it to be protected, and how does the subdivision deal with that particular area, which may in fact put it in its own pot, or may in fact provide it.
Would that then send a sort of like an encouragement to developers? Say, well, no, let's see how many lots we can do.
Not under that rule. That rule's quite that's mechanical, and it's provisional.
The environmental benefit.
Correct. That's
so you're limited by 10.
Exactly.
So there'll always be
a slot.
That's right.
But it could be different in each situation.
It could be different. It will be different in each situation. because each situation will have different characteristics of the site and different the area of the feature, area of the parent title.
So your evidence is that not having a minimum will not necessarily have any, not having any impact on the number of sites, because that's controlled by the protection of the indigenous area.
Of the rule itself, that's exactly right. And stepping beyond those metrics, I suppose, that gets into non-compliance. There's no question about that. It's within the structure of this law. It's the obligation to provide minimum balancing.
And let's say we're not prepared to go that far, but we have a reduced minimum. Is there another you want to offer?
No, because I think that's throwing down to the dartboard, because I understand that the basis of the 40 relates back to the 40 from the proposed district plan. And that just automatically sets up the assumption that there is a balanced, productive rural area within the subdivision, which I suppose my evidence is against that presumption.
Yeah, okay. So I think what you're saying is the balance will be what the balance is after the indigenous vegetation, I think, and other features are protected. That should drive what the balance area is,
That's exactly it.
rather than having another pejoratively worded target.
Good. That's exactly it.
I think I understand.
Yeah, I do have a couple of questions. A comment initially. You mentioned there that council identified lot sizes less than 20 hectares in an early night, I think. I was involved in forestry North Oakland. There's probably around 3,000 hectares there that was planted, subdivided into 10 and 20 hectare lots and sold as retirement funds because it was an affordable amount to look at. And in addition, we've got a lot of our horticultural land that has been fragmented. So I just wanted to draw you to PX, your subdivision PX, and talk about that. A broad subdivision that results in any potential for cumulative loss of availability of productive, highly productive. Cannot demonstrate that refers to the highly productive land, fragments land parcels no longer able to support farming or forestry. Now, all those things, what I understand you to be saying is they can't support it now, they're already too small.
That's correct. That was certainly my evidence here and now. That still stands. I suppose the evidence today is specifically in relation to the rural lifestyle subdivision and campaign subdivision, but that's fundamentally point in relation to a lot of the district, and that's based on the metrics that, as I say, and I've actually attached those to the back of my evidence, which were presented in section 4. Now, that says, I do concede this, that says nothing about how those parcels are held together, because, as you know, they're often held together in multiple titles to make up a farm. That said, it would still point up to the conclusion that the majority of the sites in the district are less than.
Well, then the next comment or question is the horticultural zone. A lot of under the prior district plans, going right back to the 87 plan, probably the lot sizes for horticulture was 6 hectares, which was deemed appropriate for huge frequency. But most, or there's a significant number under 3 or 4. Would you consider if you added tests to eliminate soils or property based on size, contour, soil, water, for an economic business case?
And as I remember my evidence to here and now, I think that's where I got to from memory in relation to the suggestion that there's a new restricted discretionary class for 20 hectares. There could be that sort of evaluation. Those sort of matters would be matters for evaluation of the actual productive potential of land for subdivision.
So would that support your removal of minimum area. There's no balance stock requirement.
No, I think that there is the two issues are separate because the issue I see then remaining for the environmental benefit subdivision is that still allowing it to apply to lots that are 20 hectares or smaller, which do exist in the production zone.
I think my comment may not be quite clear enough, but if you're talking about avoid something that fragments land parcel into levels or productive farming. I live in an area where most of them are 3 hectares, and there's some nice gardens there. But either contour soil, it's got irrigation water, some of it's available, but it's broken and floppy, and that's why it's been removed. It'll never be recovered. Even if you took it on stock. Every, 10 of them and got sort of 20 hectares to use, you'll never use it because it's the wrong shape and so forth. And then the economic business case, what I was thinking of was, if you think hydroponics or tunnel houses, it's massive capital costs to get going. You need more money to make it viable.
And I think we're at where it becomes particularly important for the environmental benefit rule. If you look at the purpose of that rule, is about in part protection of the conditions of biodiversity. So by its nature, that isn't or shouldn't be isn't productive land, or should it be productive land? And so you do automatically point at the need to then identify or to allow for that allowance to apply to smaller lots that are latent vegetation and should be protected by the rule. And so none of that productive type of concern should apply in that instance, because it shouldn't in fact be consideration.
And then your environmental bonus concept of joint ownership, collectively manage that balance area. I've seen lots of examples where it doesn't work. The ones you mentioned, in some farms that do work, they're big enough, and they're obviously funded by those lot owners for the original development.
I think it's the nature of setting up a rule that we can't presume failure of it, because, as you say, there are examples that works very well with those outcomes that we achieve.
Wasn't really a question, it's more a commentary. But those are the sort of things that I'm juggling as well.
There is one last returning back to the management plan. This is by way of response to evidence provided by Mr. Riddell, and you'll hear from him next. Just to note that Andrew and I are in alignment on the need for a policy framework to support management plans, and having worked together on that very thing. The last district plan, we see this great benefit to bring it over. We are probably in disagreement is around density and lot size, where the management plan rule, as notified, had a lot size of 2 hectares. And officers recommend that be changed to 1 hectare. Now, I suppose I fundamentally see that as perhaps differently than Mr. Riddell as to what it means. What it is, in effect, is a trigger between discretionary activity and non-complying. And so I thought, what should be a sensible basis for the trigger? And as I see it, it's where a management plan subdivision would tip land use into something which is no longer rural or residential, therefore denser than 1 or 2 hectares, and that means it's a much higher density. And that logically would be a sensible trigger to say that at that point there is the need to classify that greater density non-compliant or assess them against the objectives and policies that have achieved that. So from that basis, the submitters supported in their evidence, in the submissions 2 hectares as the notified version. In my evidence, I've sort of no objection to 1 hectare, because in my experience, between 1 and 2 hectares is a typical size for a rural residential subdivision. Lastly, I don't see a need to change that threshold in coastal overlay. And bearing in mind that the coastal overlay has been mapped to not be cadastralised, for want of a better word, so it doesn't apply to national boundaries, it applies to the coastal environment as we well understood it on those ridge lines, various dominant roots, etc., various species, the rest of it. So, and from a technical level, it is very difficult to have an average lot size of one thing on one side of that line and the average lot size on the other side of the line of another, when the average is to be applied across the title as a whole. It's from a technical level. I think probably at a more substance level, I don't believe it's necessary because I read a lot of very directive policies in the coastal environment part of the plan and the outstanding natural landscape features parts of the plan, which point to what would be an acceptable outcome in terms of the subdivision in the coastal environment. So I suppose I just want to emphasise that the management plan is fully discretionary consent, and so there's no, under that regime, there's absolutely no guarantee that the minimum lot size will ever be deemed appropriate. That would be, it's a feature of an assessment of the land, its site, its carrying capacity against that policy framework, which is well set up, and well set up now through the higher order policy documents, which trickle down to the district plan. So it's some questions on that. Maybe it is, yeah.
I don't have any questions on that, but I do know that your evidence sheet had some recommended changes to policy 9 and rule 3, which you haven't talked about today. Do you want to just leave that with us, or something?
Yes, just get the right reference.
7.9.
Yeah, that's right. So, 7.1. Yeah, I just to confirm that in effect is a reproduction of that same logic. The same logic applied over to the rural lifestyle zone. The management plan has already effectively set up the same structure to the policy, one dealing with rural production, one dealing with rural lifestyle. So, yeah, apologies for that.
Okay, that's the basis for that. And then that rule sub 3. Paragraph 2. That's come through. That's the balance allotment again. Suggesting that 40 hectare go to 20 hectare in that particular.
In that case.
And the rationale here is that simply adopts my position from here at 9, where I'm recommending lot size wholesale of 20 hectares rather than 40 hectares. So logically that carries over into that rule in the same way. Because this is the particular rule that is proposed to be introduced, which allows us a controlled activity, the subdivision of a legally established building on a farm block. So that being the case, what should the balancing area be? Yeah. Just for consistency with my previous evidence, I changed to 20 rather than 40.
Understood.
But you're not seeking an overall 20 hectare lot size of production.
Yes,
You are.
I am.
You are.
Yes. It's
Any
changed
rural production zone as a minimum lot size of 20 hectares.
Right.
Do you have, I mean, obviously, we've read the Section 32 analysis that put a very strong economic rural production case for 40 hectares. You know, that's been pretty much that zone strategy has relies upon. Do you have you got some economic analysis that says 20 hectares will still achieve same as that Section 32 analysis?
No, but I also wouldn't, as per my evidence theory 9, I wouldn't justify that as a very strong argument. The careful reader of the economic analysis points to a theoretical economic yield out of a lot size, not a real yield. So I've accepted that evidence, and in my evidence, I've set up some other planning factors that should weigh against that. For example, the At what scale does rural character no longer become rural character? And so I said, well, that's achieved at 20 hectares. What's a manageable block, for example, a bush block, and that is more likely to be manageable by an individual that's not not doing rural production at 20 hectares rather than 40 hectares. So I suppose I'm able to characterise it all very strongly from analysis. So I said it is one. But no, I don't have any counter-economic evidence other than my hearing underlying planning evidence.
So your planning evidence is you don't think the economic evidence is a particularly strong case, and that there are other planning factors which they have regard to. Obviously, I'll need to go back and read your hearing. So thanks for that reminder.
I've just done a summary of that, the back of this evidence, but that also was included in the hearing.
So just to be clear on that, in my mind, if we're looking at sub S1 in this chapter, where it sets out the allotment sizes, your evidence to us is that the rural production control activity should be 20 hectares, that's not 40, which is consistent with your hearing 9.
That's correct. And also at hearing 9, I considered that in order, this point earlier, in order for an evaluation of the productive capacity of the block, that those matters could potentially be added as a restricted discretionary allowance as a first step, and the essential matter of discretion would be around is the land doesn't have productive capacity at the moment, and I think I said maybe a lot of land doesn't. So it would in fact, that subdivision would in fact pass the test. We mentioned noting that 20 hectares at that scale would still retain a rural character rather than a rural residential character, for example.
But you're not disputing the economic opinion about viability.
I just don't think, in my opinion, that economic evidence is of minimum value, little value. I think it sets up a theoretical notion that has been used to derive minimum lot size from. But as I say, I point to particular parts of that in my hearing 9 evidence, where I think it's not a strong basis at all to support 40 hectares. The theory being that at 40 hectares an individual can make an income. So that I think is a basic theory is it holds just a little shaky.
I'll go back and reread the evidence on one of the things that we did know was that nobody put any counter evidence, economic evidence, which was a little surprising. But that's one of it. Thanks for the reminder. I'll go back and reread the hearing 9 evidence. Obviously, we've not made any determinations yet, so it's still churning away. Now, we always knew there's going to be a strong link between hearing 9 evidence.
I don't think necessarily so, and I think most definitely, and it's a subdivision topic, and we're in the subdivision topic now, so it does get another hearing at this point.
Yeah, I mean, I think the officers were quite pragmatic when they said we had to talk about lot sizes and when we talk about the rural zones.
Mm-hmm.
And whilst they've been criticised by others for doing that, we sort of thought that was, oh, I mean, you have to slice and dice your district plan, and it's always not going to be perfect. I think that's the argument is that's a pragmatic approach that we support. More questions? Great, well, thank you very much. Another very succinct presentation and an interesting discussion.
For the opportunity, we'll see you for the last time.
We'll see you next week.
Down at one.
Well, that's where we're waiting in next week, so.
And I think you're online. Yeah.
Mr. Rennell, good morning.
guys. This is my last one.
We've appreciated your attendance right throughout this hearing process and your commitment to making the plan work better, assisting us in that regard. So we're very grateful for your participation.
Yeah, I suppose one of the things that concern me is that I think that in this plan is for various reasons a loss of institutional knowledge of why things are hard. And that's where I try to come from. It's explaining why things. So the main issues that I talk about in my evidence are the management plan and some of the criteria. But I think the important issue here is that it's my opinion. Well, the first thing is that the management plan rule is developed as I would describe quite close supervision of the environment court. There were two hearings where directions were issued, and then it ended up with a settlement conference where the wording was sorted out on the spot by Judge Newport. And there's a couple of propositions or statements which I think are really important underlying the management plan. The first one in this case is that there's a resource management need in terms of Part 2 of the Act for stricter controls in the coastal environment, which is why the 6 hectare, 2 hectare split in the existing plan. And what the environment court reached on Ponderay was a 10 hectare average lot size for management or pseudo management and in the Hawaii district through the unchanged 5. The second one is that all of that happened under the previous national policy, New Zealand coastal policy statement in 2004, and the original regional policy statement. I wouldn't say that true, and I reached the conclusion that the new coastal policy statement, the new regional policy statement, the addition of a number of other national policy statements, the addition of national planning standards do not change in any material way the resource management policy direction that existed at the time the original management plan was developed. I think the Far North was the first to develop that process back in 2005, 2006 was the first model of the management plan, and it's been well, that's not the right word, but it's certainly been included in a number of other constructs. I think the important thing here also is that we're talking about a rule which has an average minimum lot size and a minimum lot size. And a 6 hectare average minimum lot size still allows a number of small lots, but has that mitigation factor of the setting where in the coastal environment the existing natural character is much more protected because you've got larger buffer areas for the 6 hectare average. If you've got a 2 hectare average, basically there's no buffer, there's no protection for the existing natural character and so forth. And I think the intent of the management plans is to provide for some more intense housing development in order to protect the larger area. 2 hectare average, you could just, you could. And I've seen some subdivision applications that put the management plan, we basically just divide the whole area up into uniform size blocks rather than a cluster of development, or isolating the carefully chosen sites and large buffer areas. So in the coastal environment, I think that need to have more stricter controls in the coastal environment because of 6A, 6B, and the coastal policy statement, the marine policy statement, staff policies, and the district plan policies. Needs to be more than just relying on the discretionary activity to pick up those differences. I think it also needs to have a clear, higher average minimum lot size in the coastal environment compared with the rest of the coastal. Still, because that is an important message to people who are trying to propose management plans, or looking at management plans, subdivisions as an option in the coastal environment. You might notice that in the Marine Court decision, the Environment Court was a bit skeptical about the 6-hectare average, and ended up with a 10-hectare average, which is a bit interesting because it will be going to a 6-hectare average in farming. But anyway, it's fine. The other important things I think in terms of management plan is, and maybe I'm suggesting a different way of doing it, but we need to have a statement that actually says this is what a management plan is intended for, which is superior environmental outcomes. The other second policy I've put in here is one which is a lot more aimed at giving guidance to people who are thinking about management plans, about the importance of the house locations, the built form, how you deal with that, how it is minimised. Ideally, well, certainly encouraging clustering of development, but that's not always the case. It happens, but it's very much, I think, it's called the common unit. They're actually spread out a lot more. Melbourne Land is a bit more clustering. Some of the others are just, and then the last bit on mention is adding some criteria, at least for guidance, because I think that there's a couple of areas where experience of looking at applications showed me that these are not cheap. These are not cheap proposals to put forward successfully. And I think the financing is a really important consideration. And I have seen management plan applications which are really not set up to be successful because they don't pay attention to the long-term need for financing. So they just basically run something like each year the residents association decides how much to do with them, rather than having some sort of endowment fund or something like that. So there's a number of cushions that they put in for that. The environment benefit law, which that broad legislation have a table in this, these are the bits which I think are missing from it should be put into the matters of consideration. And the last one is just a repeat of what I put in of my evidence from the history hearing in relation to this subdivision, essentially saying that the rule pretty much turns all subdivision in the coastal area to discretionary. It's asking, shouldn't apply in the urbanised areas where the rule would doubt what the subdivision also should be in the coastal area. So that's in particular zoning issue. I do also just raise the issue and put it in there, the logic of going from a 1 hectare minimum lot size in the environmental benefit rule to say consequentially we can change the average lot size in the management plan. I think we understand that there's any needs for legal needs for approval. Yes.
Thank you. I recall your evidence from hearing 9. Have you had a look at the council reporting officer's right of reply following that evidence? That's all been posted online. I was wondering whether you'd had a look at how Mr. Wyeth, how Mr. Wyeth responded to the evidence and made a number of changes to the coastal provisions, which I think your evidence is focusing.
Hearing 9 was the coastal.
Oh, sorry, no, we're talking here. Sorry, my hearing's mixed up. Hearing 4, and I remember that was the one that talked about coastal overlay provision. Sorry, which was straight. I was thinking coastal provision. So there were quite a number of recommended changes to those provisions. Have you looked at those?
If I have, I can't really recall. It was quite some time ago, but
I know it was over a year ago.
The particular thing I was interested in was the response to excluding general residential within the coastal environment from rural cruising, because that's the one that I think was the most problematic in my evidence, because it hadn't had the analysis that some of the other areas. If the recommendation was really particularly for us all that R20 shouldn't apply because there was already the subdivision rules there.
Yeah, thanks, Mr. Riddell. You raised some really interesting points, and I just want to kind of make sure that I understand your evidence. You haven't given us any sort of exact changes that you're seeking to the provisions in your evidence area in terms of specific wording changes to what's been proposed. You're sort of raising these issues, but not offering an alternative, I guess.
Right.
Is that?
Yeah, I definitely offer a different number to 1 plus 2.
Yeah,
yeah.
Yep, got that.
I put forward, just take that thing.
I think you were advocating that there be a restricted lot size within the coastal environment.
Yeah, and that's
exactly
R21 is specific to the coastal environment, and they're kind of just saying it's discretionary.
Yes.
But you're saying there needs to be more detail around that.
Yeah. So in terms of that, the first thing, just like the 43 I mentioned, wording that could be added in terms of just making really clear that you're not double dipping, or not having a chance of double dipping.
Sorry, just that rule 7.
Yeah.
Yeah, and I understand that.
That's that one, right? So that's specific wording.
Okay. So that's adding in another.
Just adding some wording and add the following to the original version of the law.
Oh, yeah.
Yeah.
It's just.
Yeah, 68 is a new policy.
Okay, just before we go,
Which is the one that I think Peter's worked into a different policy, which the important thing there is that it sets out what the point of the management plan is trying to achieve. Well, I say that, I think we did explicitly, that's the policy I would recommend.
so that's 68, I've already announced that wording there.
Yeah.
You're saying that that could be a new policy?
Yep.
Okay.
So just as a comment, some P8 recommended talks about achieving the environmental outcomes required in some R7, but there aren't really the outcomes required in some R7.
Yeah, we went there yesterday with council officers, and our understanding is that that's probably to appendix 3. Is that correct?
Yeah.
Yeah, we thought, well, where are these environmental outcomes? But appendix 3 is part of that rule.
That's right.
Yeah, so I think it's just really, it needs possibly a clearer link to that, the appendix being part of the rule.
Yeah.
So, and I had a look at that appendix, and that does set out some environmental outcomes quite clearly.
Well,
It's just that your average person would just look at the rule itself and stop.
I do discuss that in my evidence.
Yes.
So it's not desirable to put that there when you should have it in the policy.
Yes, and I think that's where you and Mr. Hallmark are quite consistent. It says don't rely on the rule or an appendix to set out the purpose.
Yeah.
When you could put it in the policy, I think that's your evidence.
And then at 70, I set out a longer policy about specifically about the design of that subdivisions. And if you look at 73, at paragraph 73, I say that policy should be just limited to R6 and RC.
That's really good.
In terms of the environment lot ones, it's in the right-hand column of the table, yes, there is a mix of, should add something in some specific wording, not incredibly well laid out. Without having to go there, with landscaping on the table. So, for example, if you go to the page 22, paragraph 80, the first one, it actually does provide the wording in the first row. It actually does provide the wording that should be added, and I suggest should be added on the right-hand side. It's specific about protecting the whole area. But it's on page 23 of the second row down, which is about more details provided on the content objectives. That's probably the one where I haven't provided the wording. I'll just say add further matters on objectives, monitoring and reporting, and funding the necessary action. At one level, I think it's fairly trivial to write a matter of discretion in relation to the objects of the plan and things like that. So, but it's important to know what you're doing. Translating that through. And then at ABA, I'll provide the matters of control or discretion as relevant that should be added to specific rules.
Okay, that's really good to walk us through that. Thank you. It's been very helpful. Can we just go back to, rule 7, and your suggested changes there? Just so that we're really clear, because what I heard you say earlier was that by the averaging, it allows you to go less than that number, whether it's 1 or 2.
Yeah.
Does your addition solve that problem or not?
Well, I think the benefit of using the averaging is you can have a number of lots smaller.
So you don't have a problem with that?
I don't have a problem with the averaging. I think the average number is completely inappropriate for the coastal environment. It's a Competition Act and everything else. Because it is the management plan subdivisions that I've seen are of two sorts. One is a small, that have a number of small building envelopes essentially, or building envelope type things surrounded by a large area, a large market area, which on average, which meet or exceed quite average. And, examples there are the land in Marino, part of land up in the west of specific environment court decision saying here's the intent of what we think we do. Management plan, without them. And then there's the other ones which I've seen. One of the I can think of immediately one of the rural production rural area. On the road out towards Torrey Bay through Pongal, which were basically the lots were all the same size. The management plan was set up so that each had the responsibilities and there was no joint responsibility for anything. And a second subdivision proposal for in the rural a bit more was in the I have not I'm a little bit confused about the number of different sales names here, but it's working to the half hectare average, and basically there's a whole lot of lots which are you could call the normal subdivision, and the protected areas are on particular lots, and it's that owner's responsibility to provide the environmental protection in this area of lots.
So the evidence is coastal environment should be stricter.
Yeah.
And so have you recommended a rule change? Are you recommending a change to, or probably just one, to say, except for the coastal environment where it shall be? And what do you think the forgive me if you've said this and I've forgotten it. Can you give us an indication as to what you think, if there should be a carve out for the coastal environment, what is the minimum lot size, the minimum average lot size method that you recommend should apply to coastal environment?
The minimum average lot size should be 6 hectares.
Okay, so we're going
which is no change from what there is.
That's the operative plan.
Only in the coastal environment.
So the operative plan has a coastal zone. Yeah, and it has a 6 hectare average.
Yeah.
Is that correct? Right, and that's what you're seeking to put into the coastal overlay.
Yeah.
Because obviously when you look at the structure of the lot size, S1 in the subdivision chapter, it just refers to size.
Yeah.
But what you're saying is that the coastal environment should be given its own status and minimum average lot size as an overlay.
Yeah.
Not just as a site. Is that the relief you're after?
Yeah.
Okay, so I'm just going to write this down. So it's sort of quite clear, and so the council officers know exactly what you're after. So you want 6 hectare average or absolute minimum?
No, average. Minimum average.
Okay, 6 hectare
as a discretionary activity. If I recall right,
Only within coastal zone.
yeah, if it's rural, the rural production zone plus with an overlay. Coastal zone.
Yeah,
So you-
assuming the coastal, I think the coastal overlay only mostly applies to rural areas. It's got some urban in there, that's
It's
not.
not urban, but that's up there.
So where it's not urban, it's pretty much.
2 hectares.
I think
Yeah,
there's some lifestyle subdivision probably that's coming across, so you would, then, if we were to go there, you would say for land within the rural production zone with coastal overlay, the minimum lot size shall, average lot size shall.
Yeah.
And you would probably frame it all to say, except for land within rural production zone, coastal. Is that what you're asking us to consider?
I'd say that this is yet another workaround forced on us by the national planning standards. Certainly in my experience, there's been a number of workarounds. For example, we've done carried over, we've got to have a workaround their definition of earthworks compared with the earthworks that are concerned in terms of carried over. So,
And just to clarify, you have no issue with the 1 hectare minimum average applying elsewhere.
no, I do have an issue with that, and the issue I have with the 1 hectare average
You want to go back to 2.
is that there is actually, it's put in there as a consequential change to a minimum lot size, not a minimum average lot size in the rural production for the environment benefit. And it's not a consequential change to take a minimum lot size and then bang it into the minimum average lot size because they're quite fundamentally different things.
Did you say minimum lot size should not apply to urban areas as well? In that case, should not apply. Is that what I heard you say?
No, I was saying that subdivision rule is, 20, which makes all subdivision in the coastal overlay a discretionary activity, should not apply in urban areas that they have a coastal overlay where their subdivision rules have already been developed for that area. And there's a particular concern with Kotlaka township zone because that has particular control activity and lot sizes. But because it's also a coastal overlay, the control activity lot sizes are deemed of no effect, unless you take out those urban areas. But that's the only bit about the urban areas, and that was something
So just to clarify, you oppose the change from 2 hectare to 1 hectare in this one and this 3? Or just this one?
Hmm?
Oh, so this one was the average,
Yeah, no, yeah,
because the average lot size has been recommended to be reduced.
yeah,
This 1 and 3.
my opposition to the 1 hectare is where it was a 1 hectare average minimum, not opposed to the 1 hectare minimum lot size, where it's an absolute minimum.
So
It's only
it's only this rule.
it's only rule us. R7, sorry,
R7, this one. This 1.
yeah. The R7, R7.
And not R7, this 1.3.
It's a different zone, that one.
Yeah, it's a different one. That was going to be my follow-up question because that's a different zone, right?
It's just one. It should be. I don't think there is any legal ability to change that, but I can't see any submission seeking that change in And as I say, it can't be a contribution tag.
Okay, good. I think I understand that now. Thank you for clarifying that. Sorry, it took me a wee while to get it.
I've got one more question on a different topic, the financial side of things.
Yeah.
You mentioned, these things need to be financed. There's no plan type applications. What's your solution to put into the plan? Like, is there a bond or something like that? Or is it?
No, I think that's the first thing is that I do mention that for the environment benefit rule, one of the criteria, one of the management discretion should be the funding mechanism. I have a concern about a funding mechanism where it is a promise to pay in the future for a landowner through a landowners committee deciding annually how much they're going to pay, because when times get tough, the money isn't put forward, as opposed to type of model which can occur. It's also viable, which is at the time of sale, a percentage of the money is put into some sort of trust fund and then allowed you to have that long-term money. But surely, because we're actually talking about basically they use the word sort of maintain and perpetuity.
So that would go into
I think it's
Rule 6. That is a description for Rule 6.
yeah. In fact, it's on the page 23 of my evidence in the table, the second row. Add further matters to others on objective monitoring and funding of necessary action. So that would be the certainty or the adequacy of funding proposed. That sort of thing. The other one I do note is one of the is relating to funding about bonding for planting in the management plan. Appendix should be a note that some of the areas, well, effectively because some of the areas are very difficult to replant, bonding might not be adequate and it just doesn't happen. I think that became an issue with planting suddenly Park and Beach, where I think it was the boundary subdivisions. The planting had to be revisited a number of times. So just a note that just because you put up a bond, or just because the applicant puts up a bond, doesn't mean the council is necessarily going to accept that when there is reasonable doubt that the planting is going to be as successful as intended. The third one about financing is where the management plan comes up and just says, doesn't actually have any joint funding or anything like that. It just says, this bit is protected, it's on this lot, it's up to that management. Which I think is exploiting the management plan provision, but not in the spirit of what it's intended.
This helpful. Thank you.
Thank you. Yeah, interesting. So yesterday and today, we've gone back to hearing 4, hearing 9, 15C, which is rezone requests, and then a variety of things today. You said this in this subdivision for particularly management plan, just talking about that, you suggest a statement management plan is to provide better environmental outcomes. That's not currently there.
Mm-hmm.
Is that currently in it?
It's not in the policies, no.
Okay, and then
There's
While you're hunting, Mr. Hall also said management plans, environmental benefit and collective community of care, but it lacks clear outcome directions. And he also suggested there's nothing that we can test it against. The outcomes, we've got no tests in the plan currently to how do we.
Yeah. So at paragraph 55, I do mention a preamble to in the appendix. The preamble in the appendix does set out something along the line of some sort of outcome intended for the management plan. But as I say, it's not that is not a good practice place to put the intention. And I think the intention is that the important thing is the superior environmental outcomes. Is that going to be achieved, this or not?
Okay, so now a question which relates back
suggested
to
in the policy, in which I think Mr. Hall was also suggesting, but using different wording. Working into an existing policy was I'm suggesting to put it in as a separate policy.
I think Mr. Hall said that the current management plan sets out the info required, not what we're going to test it against. If we go back to one of the comments in hearing 4 was, and I'll mention it was David Samuels. He said environmental benefit should be considered due to the sewage plant. So we're looking at the whole community benefit. Is that put into the management plan concept or process? Because if you look at that particular Mount Carey complex, their management plan, they've got a wetland, a sewage plant, they've got a whole lot of stuff set aside, but there is a greater benefit for that entire community because of looking after the water quality. Doesn't apply to one area of the but anyway.
I think that some of them is a management plan plus environmental benefits combined into one application because of the allocation that's available from victims. But that's with the disposal, but most of them it's pretty much the application I see people on the people buying a lot on their own due to setting up their wastewater scheme. No, I can't recall one that actually provides a single collection, treatment and disposal really.
I agree, and I was involved in that way back, and that was.
I do know this stuff. You know, the last time I was over the mountain, and there were a lot of algal growths in the corners. I think it was just basically runoff from the farming.
That's.
It's not always get what you achieve immediately. In fact, I think they had a little bug, a couple of weeds running around.
I think the other thing about management plans in that coastal area, they're looking at site separation, so privacy, visual or reducing visual impact, protection of new sharks, and to get high site values, they need all those features. But then to achieve it, the environmental benefit provisions like fencing, plantings, wetland protection. You know, there's a lot of enhancement as well as protection for existing.
But that, I think that's broken the rule as well. Certainly, the criteria and intention because, as you say, they're not a cheap type of subdivision. To start with, we've got a landscape architect to do a fairly intensive plan for the whole property. Then you've got the planting doesn't come through. The maintenance definitely doesn't come through. And I think the successful ones are simply very much high-end subdivisions. And although Mataka and New Road Station are under the general control activity, they are effectively management plans for stuff. had the same sort of issue that I think a lot of them said, so how much risk does the applicant want to take in case of mitigated notice? The landing alongside is a non-compliant activity. They want to go lower, smaller, some average than 660. As it turned out, they worked out that they had too many, they identified too many house blocks after the consent and moved to numbers because they were getting good feedback on how close the houses were in some of the sites.
Thank you.
So any questions in clarification from the officers? Okay, well, thank you very much again. And again, thank you very much for your attendance throughout these meetings. Very nice to us. We really appreciate it. Okay, and I think we now have an online presentation of evidence, Top Energy, Mr. Badham and Mr. Collins. Hello, Mr. Badham, can you see us?
Yeah, good morning all. Nice to see you again.
Yes, nice to see you too. And Mr. Collins with you?
No, so an apology from Ms. Collins. She won't be attending today. So just myself presenting today.
Okay. Well, then we'll hand it over to you.
Okay, thank you. So as you'll be accustomed to, I have got a brief PowerPoint presentation which I'll take you through relating to my evidence for hearing 16. So I'll take you through that and happy, as per usual, as we go, if there's any questions or comments you'd like to make at a particular slide, please interrupt and we can have a discussion or questions as we go. So I'm just going to share that up, make sure you can see it. Yep, just like you can.
Yes, thank you.
Okay, so what I'll briefly cover is my evidence on the policy framework. I did note minute 36 from the panel, so I do have just a brief response to that. And then as necessary in response to the minute 36, I have got my evidence in summary of sub-rule 10, but again, when we get to that point, I'm happy to take the steer of the panel, whichever way, whether you want to hear that or not. I will then go into sub-standard 6, which deals with power supply. And just a note here that I have had a look at the evidence from the telcos. So Spark, I think it's Spark, One New Zealand, and Chorus as it related to telecommunication supply. So I do briefly make a comment on that, albeit I didn't address it in my evidence. And then I'll just finish off with some summary and takeaways. So moving forward to the policy framework, Top Energy's submission sought amendments to objective sub-rule, sub-objective 2 and sub-rule 11, essentially to ensure that subdivision does not compromise the electricity infrastructure network, e.g. the critical electricity lines, but also to include consideration of reverse sensitivity effects at the time of subdivision. So that's within policy 11. Also sought a new policy. Essentially, the reporting officer's recommendation was it was rejected, and considering that the protection of infrastructure is already appropriately provided for in the objectives and policies in the infrastructure chapter. Look, my point here was a pretty simple one. Look, I've made this consistently throughout the various hearings for the proposed district plan, and that's regarding the really strong avoid directive in the regional policy statement for reverse sensitivity, but also as it relates to regionally significant infrastructure. So the point I made in my evidence, was trying to make, was that sub-rule 10 does not presently implement any objectives and policies within the subdivision chapter. And I thought and consider it is clearer to have an objective and policy within the subdivision chapter that signals this intent and that the rule gives effect to. So these are I'll go through the two slides here. The one recommendation that I'd made was objective sub-02. So currently reads subdivision recognises and provides for, I won't go through clause A. Clause B. I had recommended the inclusion of clause C, which is aligned with Top Energy's submission that says protection of existing electricity infrastructure, and then says in particular the mapped critical electricity line overlay. The second change I signalled there was to policy sub P11. This is the sort of assessment policy. I think I've been referring to them as the assessment criteria type policy that all of the chapters for the whānau district plan seem to have. And there is one A which had been added, which I have recommended editing. So my edit was the potential for reverse sensitivity effects, and I put on existing infrastructure, including electricity infrastructure. Again, yeah, so just the wording there consistent with Top Energy's relief. The final point I made there was the inclusion of a new policy. And really it gives the basis and the foundation within the subdivision chapter, in my opinion, for the sub-rule 10, which is ensure that subdivision and future land uses avoid the potential for reverse sensitivity effects on infrastructure and regionally significant infrastructure by ensuring suitable setbacks are achieved at the time of subdivision from the mapped critical electricity line overlay. So that in my opinion is a policy that establishes the basis and the foundation for the rule that's already included, rather than assessment one, and essentially is allowing for the setbacks to be achieved. I do briefly here have a response to minute 36. So yeah, acknowledged, although I did not see the letter that was received, I saw the minute, and that had concern raised by Mr. McPhee on behalf of the Oromahui landowners rehabbing 2 bites at the cherry. And I just want to say here that, to be clear, I have addressed and responded to sub-rule 10 in my evidence as it was raised again by the reporting officer in hearing 16 section 42A report. So basically I responded to it because it was in the section 42A report. I've responded and engaged with the wording, and there is actually a slight adjustment to where I landed based on the wording that came through in that section 42A report based on the right of reply from hearing 11, as I understand it. I have no issue with Mr. McPhee. I don't know if you had a presentation from Mr. McPhee or the Oromahui landowners yesterday, but I have no issue with that. But ultimately, all things considered in the round, I'm happy to take your lead on this. If you would prefer me not to talk any more about sub-rule 10, then I'm happy to skip over that in my presentation and just let it lie. Or alternatively, I have got some slides here which just explain my position. So I'll pause there.
Yeah, okay. Well, minute 36 says what it says. That said, we want to hear your planning argument as to why you think at least that activity status should apply.
Mm-hmm.
And we think it's appropriate to council officers to be able to respond to that. I mean, we have heard the evidence. We've been there again, but we're prepared to hear your arguments, and we are interested in why you think unrestricted discretion.
Okay. Yeah. Look, so I'm happy to take you through that. So these next few slides address that. So
just to make it clear, I mean, you're not deviating from what you said at hearing 11, right?
There is one slight change, and that is relating to the wording of the controlled, whether it's controlled or restricted discretionary. I've actually accepted the wording as it relates to the 32 metres of cells in the New Zealand safe distance. So there was a different wording in my evidence in hearing 11, and I have just essentially shortcutted that and said I'm happy to agree with that wording that Mr. Wyeth and Mr. McPhee, I understand, also agrees with it. The only point of difference I'm highlighting is the activity status. So the activity status is the argument presented in that evidence and that hearing is controlled discretionary. My position is restricted discretionary, non-compliant. So in a sense, I have narrowed the point and actually said, well, look, I think the wording that where they've landed to in the right of reply, looking at it, is actually fine. For me, it's just a question of activity status. So I'm not sure if that's of assistance to the panel. I think that's where the planning argument I have is different.
Yeah, well, we're particularly interested in why you think a restricted discretionary activity status should apply.
So I can go into that.
so given the right to apply that we've got already, and the recommended provisions.
Yeah.
We're interested in your reasons why RDA is.
So that's what I've highlighted in this slide here. Like I said, I've agreed with the revised wording. I thought that was of assistance to state that now, so it's not a point of disagreement anymore. It's fundamentally about activity status. Look, what I would say here at this point is my position on this is much firmer as it relates to the non-compliant activity status. The controlled or the restricted discretionary status, I do think is a marginal call. I lean towards restricted discretionary activity, given the approach and it's not necessarily just about the building platforms that might be created at the time of subdivision. It's also the additional development rights. So when you are undertaking a subdivision, so the trigger is 32 meters from the centre line of the critical electricity line. The way that the wording is building platforms, so no building platforms are located within 32 meters. The point where I landed is why I thought restricted discretionary activity was more appropriate than controlled, was relating to the encroachment of sensitive residential activities and also potential additional development rights that might not be associated with a building platform, because it's not necessarily just the residential building. It's also to do with safety of buildings in total. So it's the encroachment of the sensitive activity, and the building platform was one component of it, but it's also the sensitive activity around it. And it's also other buildings and development rights that could be created to it. Therefore, I had landed on the position of restricted discretionary activity status. The more important point for me, where I think there is a strong argument, is the non-compliant activity status, where it's not complied with, and that ties into the regional policy statement direction on reverse sensitivity, but also the reverse sensitivity, but also regionally significant infrastructure, which we've already previously established under the RPS is a 33 kV electricity line is considered regionally significant. So, to summarise that, I consider a non-compliant activity status as a strong basis for it. I can see how this, how you would get to a should it be controlled or restricted discretionary. I lean towards restricted discretionary. I guess taking a more cautious approach given the type of development rights and sensitive activities that could be put within that 32-metre buffer, which I think need the element of discretion and the ability to decline. So that's where I've landed with that component. That fundamental argument in terms of the activity status has not changed since hearing 11. I've just essentially reaffirmed that position in my evidence statement for hearing 16.
Okay, I think what you've said is you're not just concerned about building platform or residential building. I think what you said was other activities and development rights. And I just want to know what you mean by that.
So building platform is one thing. Obviously, a building platform. Now, it depends how that's implemented, but you can also have other development rights in a subdivision. So the way I interpret a building platform would be for a residential unit, typically, right? You say this is where the building will be located. Now, if you've got other activities or structures or buildings that could be implemented or development rights created as a result of that subdivision. So the classic example I would give would be like a rural lot, 20 hectares, or maybe it's 40 hectares being cut into 20 hectares. It might specify a building platform for the residents, but still within that 32 metres setback, you could have a other development right created for a structure or a building or an activity, the sensitive activity around it. So that's why I leant towards restricted discretionary.
Well, I mean, again, I'm sort of struggling to understand what these other activities are.
It'll primarily be buildings. It primarily would be buildings. So possibly part of the answer there.
Sorry, Mr. Madam.
Oh, sorry, you go.
Other buildings other than residential buildings that you could do as a permitted activity.
Yeah, so the subdivision creates the development right, additional development rights. So if you have an existing lot, you've got the right to build buildings, and we have got provisions within the plan around building setbacks from critical electricity lines. This is the subdivision rule. So subdivision is the thin end of the wedge in terms of the establishment of additional development rights, which can be buildings. So the safe, the New Zealand standard is primarily around buildings. It's not really making a distinction between the activity within those buildings. But the other component is the reverse sensitivity component of having a sensitive activity establishing closer to the critical electricity line. So it's both elements. It's the buildings and it's the activity. Now, the way that it's set up, if it's a controlled activity, and you put the building platforms in there, they're established and they comply with the safe setbacks, then it's controlled. What I'm saying is that we're talking about subdivision here as well. It's the subdivision component, probably not explain that very well, but that's why I leant towards restricted discretionary.
Yeah, I mean, I think you've clarified that it's a sensitive activity. The sensitive activity would be residential activity, right?
Primarily, yes. Like a definition of I'm not sure, is there a definition of sensitive activity in the proposed district plan? But primarily sensitive activity in this context will be a residential activity, yes.
Oh, I think it answers, we're talking about a residential activity, right?
Sorry, I missed that, sir.
Maybe home occupation as well, maybe.
Typically, so I have seen plans which will define a sensitive activity, usually residential activity being one of them, but there are other activities that you might classify within that, such as, I don't know, a care facility or visitor accommodation, something like that. But in the context of this, primarily it's going to be a residential activity.
And it would otherwise encompass any other activity in that zone that would be permitted.
Sorry, that you cut off just a little bit there. I didn't catch the end of that.
So when you talk about other activities and development rights, are you referring to other activities that would otherwise be permitted on that site as well? Or are you talking about other activities that might be enabled?
So I'm primarily talking about the development right, which is created, and the encroachment of the sensitive activity. So that I'm not concerned about activities that are otherwise permitted, e.g., I don't know, farming, pastoral farming, cattle. That's not of concern. Yeah. But yes, a building of a farm building within that setback could breach the New Zealand safe the setbacks and the standard, because it's about buildings. That's primarily about buildings, not necessarily the activities within them.
Yeah, okay. So what are you meaning then in terms of other development rights? Not really following what they would be. So they would justify a restricted discretionary activity.
Primarily, the additional development rights would be buildings created that could be established as a permitted activity within the setback.
Yeah, but those buildings are dwelling.
Farm buildings, yep.
Farm buildings, garages, implement sheds. We're not talking habitable buildings, but just buildings associated with the sensitive activity, right?
So the rule, I don't have the word in front of me, but the rule relates to building platforms, as I understand it. I'm not sure if it's specified.
Is it rule 10?
I'm just gonna bring up my evidence.
10.
Okay, so current.
What I'm trying to understand is what is the effect that we are trying to avoid, or at least need to manage, that requires it to be restricted discretionary? What effect are we looking at here? It's not just sensitive activity.
So I'm sorry, I'm just reading the revised wording of sub-rule 10. So proposed building platforms are identified for each allotment. Can accommodate buildings.
Yeah, so the rule is saying all buildings that comply with code of practice.
I see what you're saying. I see what you're saying. Because actually it's referring to the building platforms. So building platforms are identified for each allotment. For each allotment should be a that can accommodate. I'm going to bring this up. Can you see that on my screen?
Yes.
Yeah.
It's a bit small, I'm afraid, for my
There we go.
eyes.
See that?
Yeah.
Proposed building platforms are identified for each allotment. I think there's probably there's probably an area there that can accommodate a building that comply with the safe requirements. I think part of the issue here on reflection, looking at it, is it's accommodate a building, but is that any building? So is that where the buildings are going to be located? Because what if other buildings can be constructed on that allotment within the setback? I think that's actually, in reflection and listening to your questions and clarifications, I understand what you're saying. As part of it is possibly in this. Is it the building or a building or any building? Because if there are other development rights that are created for buildings within as a result of that subdivision, which means that the buildings are going to be closer, then if this is just saying a building platform.
Yeah.
So that's the same one building. That's the same one building. It's not saying all buildings.
Okay.
Yeah. So look, no, I accept where you're going with that, and I could, on reflection and looking at that, I could see a basis for a controlled activity status, if the wording was, I think, clearer in that regard. I think my concern is around the construction of other buildings.
So
Yeah.
you're concerned about more than a house, any building that isn't otherwise a house that could be established.
So there's two components. Any built, so this New Zealand Electrical Code for safe distances is relating to buildings in general. So that's one component. The other is obviously the reverse sensitivity component of having a house come closer to it. But if I take the point that if it complies with that standard, then that would address it as a controlled activity. I think where I was getting to and where I probably got myself in a bit of a muddle is just the wording about the other buildings, and hence why I was thinking.
Okay, look, I'm going to ask the council officers a question, which is, if a building was not located in accordance with the safe distance requirements of code of practice, what would the activity status be? Can you answer that question? Discretionary? Okay. Did you hear that?
Yeah.
Yeah. So I think
No, not off the top of my head. Look, there may be another building rule, in which case, accepting where you're going with this, if it's adequately covered somewhere else, then I can see a basis for this being a controlled activity.
Okay, the question I've got to council officers is, if a building platform was not located within the safe distance requirements of the New Zealand Electrical Code of Practice, i.e. couldn't comply with that controlled activity rule, I asked them what activity status would default to. I think,
Sorry, Mr. Chair, I misunderstood the question.
Yeah. So the rule sort of says building platforms that comply with that safe distance. So what if it isn't in compliance with that safe distance? Then you wouldn't be able to comply with that. What would the activity status be?
Yeah, discretionary.
Discretionary. Okay, so that's the answer, Mr. Madam. I mean,
I think in the course of this, that has covered actually what I've not very well explained in my evidence or presentation, my concern. So I would be happy to concede that and actually say, no, I can now see the basis for a controlled activity, for this to be controlled activity in this rule.
okay, right.
Yeah. No, I can see the logic there. I've tied myself in a bit of knots there. So but I'm willing to say that where I can see the light, and that's a point which I would accept. The bigger point for me, as I said, would be the non-compliant activity status where it's not adhered to.
And so you still have an issue with the default of not achieving that standard going to non-complying instead of discretionary? Is that the evidence?
So it goes to discretionary, and I'm suggesting it goes to non-complying, given the direction that you've got regarding reverse sensitivity in the RPS.
Okay, so that's really, so you can see that it could be a controlled activity as written, well, with this little
Yeah.
possibly addition of that.
Yes. Look, I would pick up that that does look like there's a word missing there. But notwithstanding that, I'm to shortcut this, I'm happy to concede that there is a basis for a controlled activity status there.
Yeah. But if you can't comply with that standard, your evidence is that it defaults to non-complying rather than discretionary.
Correct. Yes.
Okay. Right. Thank you. Then we've got that clarified.
I'll just go back. So the last bit of my evidence is just around sub-standard 6 power supply. So Top Energy submission supported the requirement for electricity connection at the site boundary of an allotment, but requested additional zones to be included and easements to be provided at the boundary of allotments to facilitate future connections. Essentially, the reporting officer's recommendation was that it be rejected because the reporting officer considered that was already addressed in sub-rule standard 7. So which covers easements for any purpose. So when you do a subdivision, create easements over different things. A point I made in my evidence, I don't think the reporting officer had understood or considered what Top Energy was actually asking. For instance, there was no specific response around the request to add additional zones. Also, sub-standard 7 relates to establishing an easement on a subdivision for power, telecommunications, things like that. However, what I was talking about in my evidence, but also Top Energy's submission is an easement to facilitate a future connection. So typically at the time of subdivision, you will either provide a connection at the boundary, or you might provide an easement that can facilitate a future connection, so the ability to get it. Look, and I just at this point, as I alluded to at the start, I acknowledged the submission and evidence of the planners on behalf of the telcos. So I didn't present evidence on telecommunications. That was primarily because Top Energy is not a telecommunications provider in the far north. It's electricity supply. However, just to be clear, I did read that evidence, and I just wanted to say that I agree in principle. And in my experience, telecommunications there should be some provision for telecommunications at the time of subdivision, be that by a physical connection or a wireless connection, but it is something that in my experience typically should be required and addressed at the time of subdivision. So acknowledging that the telcos have also sent sought an amendment to this rule. Obviously, there's a bit of a difference between the wording I've suggested and the wording they've suggested. I do think that they could be either combined, or you could have two separate rules, a telecommunications rule and a power supply rule. How that's done, I'm not concerned. I think that the primary thing I would say, though, is that there should be a requirement for power supply in all zones, not just those listed. And the one I've recommended rewording it. I think the wording that was existing is quite clunky and not particularly workable. So what I proposed was that all zones, every new allotment, and then I put in brackets, excluding any allotments for access roads, network utilities or reserves. So you wouldn't typically require a power supply for those, which is fair enough, is provided with a connection or easements to secure connection to a reticulated electrical supply system at the boundary of the new allotment. Now, that wording is actually essentially been picked out of very, very closely aligns with what's in the Whangarei District Plan. And I have utilised that similar issue raised with respect to North Power and Whangarei. So look, I think that wording is very clear. That's the basis. You should have a power connection. If you don't, if you wanted to go for another means of connection, then you have a process by which you can do that via a subdivision consent. I'm just going to pause there. That's to see if there's any questions or comments on that point.
Yep, that's pretty clear. Thank you.
Okay. Look, so just to finalise, the subdivision chapter could benefit from some specific objective and policy direction regarding electricity infrastructure and cells within it. I've acknowledged minute 636. Obviously, we're happy for me to have that chat, and probably by the sounds of it, quite helpful to clarify things there. So I'm willing to concede on the controlled activity status based on that. I can see the logic from that. But I do think that a non-compliant activity for when compliance is not achieved should be adhered to. And I think that sub rule 6 should be reworded to apply to all zones, include provision for reticulated connection or easement to facilitate future power supply. And I just acknowledge at the end, I didn't address telecommunications, but essentially I can see the basis for that, and I can see why that's a good idea. The wording, whether that's the reporting officers accept that and then mould it into one rule, I don't think is a problem. One rule or two rules, but I agree that you would typically have telecommunications and that power supply addressed at the time of subdivision. That's the conclusion of my presentation. Happy to take any further questions or comments.
Okay, thank you.
I don't have any further questions.
You've got a couple of questions. I think Commissioner McNally has a couple of questions for you.
Good morning, sir.
Morning. Thank you for your presentation. It's very clear. It's also very clear you're advocating on behalf of Top Energy. And we've got other submitters that we have to consider. So my question relates to what about other land use? Because the majority of these lines run through primary production areas, other land use. And under your subdivision rule 10, there's a number of matters of discretion are outlined and restricted to. And that's the safe and efficient operation and maintenance of the electricity supply network. I gather they drive underneath them every now and then. What about a change of land use? Have you considered the impact of a change of land use?
So sorry, sir. I'm just going to go to. Were you referring to? First of all, I'd just like to address one comment you made there at the start, saying that I'm advocating for Top Energy. I'm not. I'm here as an independent expert witness. So I just want to make sure that that's clear for the panel. So can you just clarify? Sorry, what was that?
I said that's my apologies. That's my interpretation. It's not the panel's.
No. Okay, I just wanted to be clear on that, because I have agreed to comply with the code of conduct for expert witnesses. So, just on the sub, can you please clarify that the first leg of your question was relating to the restricted discretionary activity criteria? Was that what you were asking?
Well, it actually relates to land use. This is primary productive land use. You're 32 metres setback outside, 64 metres. One of the submitters has 2 kilometres of line, it's about 12 hectares impacted. Mm-hmm. What about a change of land use from pastoral farming to some form of horticulture?
So in regards, are you asking that in regards to sub rule 10?
Yeah, well, it's subdivision, but it's also land use. What can be done underneath it? It's very clear you can't build a building under it. What about avocados, citrus, market gardens, kiwi fruit?
So that would be, I think, more of a question specifically in terms of the code of practice itself, which I'm familiar with, but I'm not an expert on. So I wouldn't be able to comment on tree establishment of orchards and things like that. Ultimately, the way that what I would say is the way that this rule is worded, accepting that it can be controlled, it relates to building platforms and not the establishment of orchards. So in short, I can't answer that. I don't know.
Well, I guess the question relates specifically to, we're talking about property rights and loss of opportunity for use. So you could have our subdivision where the land runs back to the power line or underneath it and have an orchard type operation, subject to a clear space under the line itself.
So you have
subdivision. The rules for subdivision alter if some of this land is rezoned horticulture.
So for that, what I would say is you do have the New Zealand the regulations for vegetation. I can't remember the exact name, but vegetation underneath power lines, which control that. So essentially the top energy or Transpower as the power provider can come through and trim trees if they are going to interfere with the power lines. So I think that's addressed elsewhere.
It's addressed in this rule as well, under E, mature skies, growth rate, location, and full zone, any associated tree planting with safety. No, that's all right. There's some other issues that are coming out.
Yeah, look, and just on that, taking the conversation I had earlier with the chair, if this becomes a controlled activity, these are matters of control, and I haven't actually proposed to change. If you're referring to these ones, I haven't proposed to change these. Those are what are established in the rule. I think you might be referring to this one.
Yeah, there's a number of them.
Yeah.
It's there's a complex overlay that we're dealing with across all of these things. But yeah, thank you.
Okay. Consider the council. Right, thank you, Mr. Batter. We haven't got any more questions for you.
Okay, thank you.
See you next week.
No, I won't be there. This is my last appearance, so good luck for the last week. It's been a ride.
Thank you very much for your attendance and your evidence throughout this process. It's been, we've been helped by your evidence, and yeah, thank you very much for being here.
No problem. I will send a copy. I will send a copy of the presentation to AK separately.
All right, thank you. Thank you very much.
Bye.
I think we'll have that according to adjournment now. I think we'll make it 11:30.
11:30, right, stopping the recording. And using the road.